Welcome back. I'm Derek Watkins from Mckenzie Friends Consultants. In today's video, I'm going to cover the top 5 tips for litigants in persons. Now, I'm revisiting the video I did several years ago because the feedback that I've got is that the video proved to be invaluable for people representing themselves in the family courts. So, my top tip number 1 is to get familiar with the family court proceedings and processes. Now, judges, magistrates, solicitors and barristers are all very familiar with the family court and its proceedings because they deal with it every single day. However, you don't. It's maybe the first time, and probably is the first time, you've been involved in these processes, and as such, it's going to be very new for you. You're probably going to be feeling a little lost and daunted by the whole process. Therefore, you must get familiar by educating yourself on the family court proceedings so you feel a little less lost and a bit more comfortable for the very first time that you go in court. Now, one of the best ways to educate yourself on the family court processes is right here on my YouTube channel. Now, I produce a series of short videos for people just like you to help you understand the family court processes. There are over 30 videos available on most subjects dealing with the family court. So just hit the subscribe button and you can watch them for free. Top tip number 2 is preparation. You can't just turn up at court, wing it and hope to get a good outcome. Now, many people do. They wonder what happened, why everything went against them, and why they didn't get the outcome they desired. You must write a position statement, send it to the court and the other party, and bring hard copies on the day. Hand a copy to the usher and ask the usher to pass it on to the judge. At the beginning of the hearing, ask the judge if they have seen and read your statement, so they will know what your position is and what you want the judge to do about it. Now, the good news is, I also have a short video that explains exactly how to write your position statement. The other top tip for the hearing is to have 3 or 4 bullet points written down in front of you of what you want to get the outcome to be and what you want covered. And tick them off as they are covered in the hearing. And if any of them are not covered at the hearing, then raise your hand and ask the judge and discuss it with the judge so that he can make a decision on those points. Top tip number 3, get your say. The judge will run the proceedings and explain matters. If the other party is represented, they will have a barrister. The barrister will take over proceedings. He will seem very pally with the judge, and before you know it, the hearing is over, you haven't said a word, and you haven't got the outcome that you desired. What happened there? Well, you must have your say. So, as you go through, you must have your say on each of the points. So, you have to do that. You don't interrupt the judge when they're speaking, but you just simply raise your hand and keep it raised until the judge acknowledges you. The judge will then come back to you and ask you, Mr. So-and-so or Mrs. So-and-so, yes. And then you say your point. And you must raise your hand on every time you wish to make a point or challenge what the barrister's just said. Because quite often what they say is not true or it doesn't meet with what you want. So it's your right to have to say, and once you put your hand up a few times, the judge will know, and the judge will come back to you automatically. Top tip number 4 is ask, ask, ask. It's very important in the hearing that you understand what's happening and what the judge is saying. And if you don't, you must ask. The judge is very aware that you're a litigating person and that you probably won't understand anything. However, he may also, he or she that is, assume that you're following matters. So, if you're not following it, just simply ask the judge if he could explain it. And it's important that you do this for each and every point that you don't understand. And after a while, the judge will take even more time to ensure that you understand matters. So, don't sit there thinking, oh, I can't ask this. Yes, you must. Just keep asking so that you fully understand what the judge is saying and what is happening in the hearing. Top tip number 5. At the end of the hearing, the judge will summarise the outcome and he or she will state, I order. And then they will state a number of points, which is the outcome. At this stage, you must make very careful notes of each of the points made, including any dates and times, as this is the order that you must follow. And if you don't understand any of the points, when the judge has finished, just ask him to clarify those points, and he or she will be very happy to do so. Now, it's important that you have these notes because whilst the order will be sent to you, in most courts it takes many weeks, and in some courts it actually takes months. And you're expected to follow the order even though you haven't received it. So those notes are highly important. Well, that's it for today. I hope you enjoyed the video. And if you'd like further assistance and you live in the south of England, then book your free consultation with me by going to www.mckenzieFriendConsultants.co.uk and book your session with me. In my next video, I'm going to be dealing with how to deal with barristers. So, till then, bye for now.